tea break. We are very fortunate today to have one of the eminent leaders in the legal fraternity here in South Africa and globally. He is Justice Richard Goldstone, who has been a judge in South Africa for 23 years. In the 9 years of the 23 years, he was appointed as a Justice of the Constitutional Court of South Africa, and since retirement from the bench, he taught as a visiting professor in a number of United States and European law schools. He chaired the Independent Expert Review Group established in December 2019 by the Assembly of the States Party to review the International Criminal Court and the Rome Statute system. He's a deputy chair of Integrity Initiative International and chairs its International Anti-Corruption Court Treaty Drafting Committee. From August 1994 to September 1996, he was the chief prosecutor of the United Nations International Criminal Tribunals for the former Yugoslavia and Rwanda. Many of us here recall those genocides and war crimes that took place in those respective countries. And as a result, he has played such a role in the prosecution of the culprits. He's here this morning to address us on that ongoing anticipation for the establishment of the International Anti-Corruption Court. Justice Goldstone, you are most welcome to address us and hear from you what the arrangements for such establishment. Thank you. Thank you. Please take on.
Well, good afternoon, and thank you very much for your kind introduction. It's really a great privilege to have been invited to address this gathering on the project to establish an international anti-corruption court, or as we call it for short, the IAC Court. The project to establish the court was initiated by an international non-governmental organization, Integrity Initiatives International, or for short, III. It has offices in Boston in the United States and in The Hague in the Netherlands. At a meeting held on the IAC Court in Nairobi about 10 days ago, the Chief Justice of Kenya, Martha Koome, described corruption as one of Africa's greatest threats. The Chief Justice cited the billions lost annually to grand corruption and illicit financial flows, often orchestrated by senior officials who siphon funds into their offshore accounts, shielded by weak domestic enforcement. She warned that corruption crosses national borders, while national systems, hampered by limited resources, jurisdictional barriers, and political interference, struggle to contain it, conditions that she said continue to fuel impunity. What Chief Justice Koome said about corruption in Africa is relevant to so many other regions in the rest of the world. The point I would like to emphasize today is that as Chief Justice Koome emphasized, illicit financial flows cross borders and is very much a transnational phenomenon. I'm sure you've been discussing it already during the week. It follows that the problem needs to be tackled by a transnational mechanism. Domestic mechanisms on their own are not sufficient. And at present, there is no international mechanism to deal with this huge corruption, particularly at the highest official level. The theft of a country's assets by heads of state heads of government, and other senior public officials meets with little, if any, opposition from their own from their own enforcement authorities. In such states, in these kleptocracies, the kleptocrats and the oligarchs who support them are assured that the police, the prosecutors, and even the courts will turn a blind eye to their plunder. There are unfortunately too many illustrations of this. Russia, some other East European states, Bangladesh under its former government, and on our own continent, the billions stolen by the former president of Angola, and in South Africa as a consequence of state capture. There are many others, as you in this room will be well aware of. In this context, one example that came up very recently is the name of Isabel dos Santos. She again hit the headlines in recent months in London. She is the daughter of the late long-time president of Angola, José Eduardo dos Santos. A United Kingdom government statement issued only last month said that Isabel dos Santos had systematically abused her positions at state-run companies to embezzle at least £350 million, equivalent to $442 million, depriving Angola and its people of resources and funding for much-needed development. I would add that that was probably the tip of the iceberg. In November of last year, Foreign Secretary Lamy announced sanctions on Dos Santos as part of a crackdown in the UK on dirty money and kleptocracy. For obvious reasons, and as the Dos Santos case illustrates, the assets plundered by senior state officials are never kept at home. Their proceeds are laundered in many foreign jurisdictions, including the United Arab Emirates, the Netherlands, Singapore, Switzerland, the United States, and the United Kingdom and its overseas territories. There are others. It is those laundered funds that constitute the Achilles heel of the kleptocrats. For obvious reasons, they do not keep the ill-gotten gains at home. It's not safe. They don't know how long they're going to be into power and what will happen to those assets. So rather, they often look forward to long lives, and they want the assets to live long after they're out of power. So the huge annual amounts of illicit flows that we know of, while these kleptocrats fear for their illicit assets if kept at home, they feel reasonably secure when they are laundered in foreign countries. Now, grand corruption does not exist because of a lack of anti-corruption laws. The great majority of the 186 UN member states that are party to UNCAC, the United Nations Convention Against Corruption, have enacted the required statutes criminalizing bribery, money laundering, and the misappropriation of national resources. However, too many states that are party to UNCAC are governed by kleptocrats who enjoy impunity in the countries they rule because they control the police, the prosecutors, and the courts. Some of those authorities are often corrupt themselves. Those kleptocrats will obviously not permit honest, effective investigation of themselves or their criminal collaborators. And we must not forget the criminal co-conspirators around the world, the banks, the law firms, real estate agencies, and other financial service providers who aid and abet kleptocrats in the transnational crime of money laundering. That is the context in which there is a developing effort to establish the International Anti-Corruption Court. Such a court would hold kleptocrats, the higher state officials, and those who collude with them, those in the private sector, would hold them accountable when national authorities are unable or unwilling to do so. The scarce resources that would be available to such a court will necessitate that its jurisdiction be principally directed at grand corruption or kleptocracy, the plunder and stealth of public assets by heads of state and other high officials, and those who collude with and enable them. The envisaged court would have jurisdiction over crimes of corruption committed by nationals of an IAC court member state, and crimes committed in the territory of such a member state. It would have no need to invent any new crimes of corruption. We would rely on those crimes already recognized by the 186 states that have ratified UNCAC. They have really become internationalized by their wide recognition. And I repeat, they include the bribery of public officials, embezzlement and other misappropriation of public funds, money laundering and obstruction of justice in relation to those offences. There are also some non-mandatory offences contained in UNCAC that are being considered for inclusion in the draft statute for the International Anti-Corruption Court. They include trading in influence, illicit enrichment, concealment and abuse of functions. They have also been incorporated in national laws by a number of UNCAC member states. The IAC court would have complementary jurisdiction. It would be a court of last resort. This means that it would acquire jurisdiction only in cases where the appropriate domestic authorities are unable or unwilling to investigate or prosecute the corruption. Member states would also be able to refer cases to the IAC court. It would be an institution able to offer what could be crucial assistance, for example, to states that are willing to investigate and prosecute the corrupt, but do not have the human or financial resources to do so on their own. The IAC court's expert investigators, prosecutors and judges could be called upon for assistance by prosecuting authorities in such countries. At least one such transnational country, Moldova, has already endorsed the establishment of the IAC court. The court's personnel could work with nascent islands of integrity in such a country as Moldova to help build its cases. It could include facilitating mutual legal assistance that is required to obtain evidence located in foreign jurisdictions. A crucial feature, and I would emphasize this, a crucial feature and advantage of an IAC court would be its authority to freeze and seize billions of dollars worth of assets that some dishonest leaders and high officials have laundered around the world. The presence of those assets within the jurisdiction of states that join the court would also provide a jurisdictional basis to investigate and prosecute those who were complicit in their theft. If there is a high risk of those funds being misused if returned to corrupted states, they could be repurposed for refugee and humanitarian purposes or repatriated only at a time when they would reach the real victims, the millions in need in those countries and their enforced diasporas. Integrity Initiatives International has been very busy during the past year in drafting a statute for the IAC court. We have recognized the importance of full consultation with the governments that have shown an interest in joining to establish the court. The statute that we have drafted, which will soon become public, reflects the experience and input from experts around the world. A number of them come from Africa. As I mentioned, we expect the draft to be ready in the next couple of months, and we will use it as a tool to engage with governments. Nigeria has for some time been public in its support for the court. There are other African states that have indicated an interest. They include Zambia, Mozambique, the Democratic Republic of the Congo, Gambia, Rwanda, Senegal, and Côte d'Ivoire. We hope that they and other African governments will engage with us in shaping the proposed court. We would really appreciate input now at the stage of formulating the design of the court. It's really an opportunity for African governments to get in at the formation stage of the court and not be presented with a fait accompli when the court hopefully gets underway in a few years to come. In our present draft, we have made provision for a two-division court, a criminal division and an assets division. The criminal division would have jurisdiction over kleptocrats and other high officials who have plundered their countries and those complicit with them. Both divisions would have authority to seize and freeze laundered and stolen assets and hold them until they can be returned to their real owners, the people of the countries from which they have been stolen. The civil division of the court would also resolve the inevitable disputes that are likely to arise with regard to identifying the laundered funds and determining their fate. It would also exercise control and management of the seized assets. This would really be a unique feature of the proposed IAC court. The draft statute, it's rather a long one, but it also reflects the lessons that have been learned from various other international courts. For example, it does not replicate the system of pre-trial chambers that have prolonged the proceedings in the International Criminal Court. Other successful international criminal courts have operated efficiently without pre-trial chambers. The operational cost of the court would constitute but a small fraction of the amount of illicit assets that it could seize and return to be used for the original intended purpose, the public good. In addition to orders for restitution, the trial chamber, the criminal chamber could levy fines on those found guilty, and those too could be used to defray some of its costs. There are now over 300 leading figures from across the world, including more than 50 former presidents and prime ministers and 32 Nobel laureates who have signed a declaration calling for the creation of the IAC court. In 2016, Colombia was the first country to call for such a court. More recently, the Netherlands, Canada, Nigeria, Moldova, and Ecuador have committed to working towards its creation. Some 18 months ago, the European Parliament passed a resolution calling for the International Anti-Corruption Court. Additional countries from each region of the world have also expressed interest in the idea. I've referred already to some of the African countries who were interested. In the United Kingdom, the Labour Party announced before it came into office in July last year that it would champion the International Anti-Corruption Court idea, and there is further cross-party support from the court in the UK Parliament, and particularly from the Foreign Secretary, David Lammy. Our most important task now is to persuade, I would guess, some 30 states to agree on a treaty to establish the court. I would suggest that such a number of states would be sufficient to make a court viable, on condition that some of them are the states where illicit assets are habitually laundered. I referred to some of them earlier. The launch of the court may still take time, but the momentum generated in the past 3 years suggests that it may be possible sooner than even its strongest proponents think. So the time is now to strengthen the proposal so that the eventual court can provide as meaningful as possible a check on corruption. In closing, let me say that it's not going to be a panacea to corruption, to grand corruption, and corruption at various levels. It's not going to put an end to it, but it would work very efficiently with existing domestic and regional institutions that are aimed to stop and inhibit corruption. We hope that the African Union, the African governments, and African civil society organizations will play a leading role in supporting the project to establish the court. As I said before, it is an opportunity for our continent to place its stamp on the kind of court it wants. It would also be a huge inspiration to governments on other continents to come on board. So thank you very much for your attention, and I'll be very happy to answer any questions. I must confess my hearing is not too good, and I've asked my friend Karam Singh, who's the Deputy Managing Director of Integrity Initiatives International and works closely with us, to write down the questions that you might have. So any questions from the floor, please?
Thank you. Justice? There's the mic there. All right. Thank you very much, Justice Goldstone. You have heard it from the horse's mouth, the vice chairperson of the committee. The fact is that grand corruption is happening in all countries, big and small economy, and justice must be done to all, irrespective of whether it's a big country or a small country. Now, having been said by the member of the committee, I will invite questions from you colleagues. And I will first take 4 questions. If time allows, after that, we'll go for the second round. And I request you to be very brief and concise with your questions so that we give an opportunity to give us clear answers to the concern that you might raise. So it's now open for questions, please. I see one is coming from there. That is yes, Malawi. I see Kenya here will be the second. Who's the third? Yes, South Africa, our host is here, the third. The fourth? None? And then Malawi, please. All right. With respect, Malawi, please.
Thank you very much, Chair. And also thank you for the former Justice Richard Goldstone for the well-articulated presentation. My question is, we welcome the initiative, but however, history has taught us we have the ICC, which of course we have seen that it's only targeting those from Africa and those small countries. So how sure are we that when we create this, the so-called powerful nations, powerful countries, will be prosecuted? Yes, we know that in Africa, yes, we're victims. Results have shown that we're corrupt. But also those big countries are corrupt. So I hope there will be, for us to have that equal footing, equal play. How sure are we? So that's my question. Thank you very much.
Thank you, Malawi. Thank you, Malawi. Yes, Kenya, please.
Yeah, thank you. I think mine is basically related to what was raised by Malawi. The current situation or the environment in the world currently, as much as this is a very good suggestion and a very good proposal, we've seen such initiatives may not work because the most powerful nations in the world are running away from accountability. Now, unless we want to create a situation for the weak countries where this court will be only for the weak countries, but really nobody has, at least very few people have confidence in the current situation arising out of what is happening around the world, that if you are strong, you can do what you want. If you are weak, laws will be created for you to abide by those regulations and laws. So basically, unless we want to have laws for the weak and those who cannot, fight for themselves, it cannot be called, in my view, international. But it's a good initiative anyway. Thank you.
Thank you very much. Kenya, South Africa, please.
No, thank you. Thank you very much for the presentation, Justice Goldstone. My question really is about, call it international governance process. Starting off in the continent, in the African continent, you have called on the African Union and African countries to support and be part of the design, even at this stage, so that they are not presented with a fait accompli. Is there a plan to present to the African Union itself? And possibly, that in the continent, really, that's the only forum where you would speak to sort of African countries. and then possibly get to have some support or, a resolution of some sort. And these questions that are asked by the colleagues here, they will probably come up there. So then it's important to then sort of indicate, given the history, what checks and balances are likely to be there to ensure that there's even-handedness, right? This court serves every country in the world the same way, so-called weak and strong, the same way. Thank you.
Thank you. That's very clear. Botswana, please.
Thank you very much, Justice Goldstone. My question is similar to that of Malawi, but maybe first just to thank you for such elucidating presentation. It's a fact that illicit financial flows are indeed part of transnational organized crime, and it is also a fact that proceeds and assets acquired criminally are usually kept in certain jurisdictions. So maybe perhaps what we need to ask ourselves before we can discuss the establishment of IAC is we should ask ourselves why these particular jurisdictions harbor these proceeds or these assets. We know these jurisdictions. Then when we come now to the initiative that you've presented, Justice, is that we currently have the ICC. We have the International Criminal Court. In comparison, is there a compelling case, really, for us to establish another court, now specifically looking into issues of corruption? Is there a compelling case if we are to now compare with the existing ICC? Is it not possible for the ICC to cater even for anti-corruption offenses or cases? That is my question. And further that, you've cited it's going to require funding, yes, but is it really where we are as a global world? Do we really need the anti-corruption court? Thank you very much.
Thank you very much. Honorable Justice, please, can you then take those? You may be seated. Okay, fine, if you want to stand.
Well, thank you very much indeed for important and interesting questions. Now, the first one, we are very conscious of the criticisms that came from Africa not too many years ago of the International Criminal Court and picturing the court as some sort of Western institution directed to dealing with criminality in Africa. Well, there are a lot of historical reasons for that. And one of them, in my personal view, was a court that was newly set up that was looking for work. And the first chief prosecutor really went out into Africa and got cases self-referred by African states. But he was the driver of those cases coming to the International Criminal Court. I understand there was a fear that the court would have no work. And nobody expected that the first cases would come from state referrals. And they came from African governments. And so it's perhaps a little, in looking back, it's a little unfair to blame the International Criminal Court for being, it was really a partnership between the prosecutor's office and some African governments that wanted to use the International Criminal Court for their own political purposes. And of course that was a bad start for the court and led to huge opposition, particularly from the African Union and the threat by a number of African states to pull out of the International Criminal Court. We've learnt for that, and it's one of the reasons that I stressed in my remarks that we are really wanting as much input from Africa as possible into the statute for the International Anti-Corruption Court. We want this to be seen as much an African court as it is a European or Latin American court. And this is the opportunity to get in at the ground level and not to be presented in a few years' time with a fait accompli, with a finished product. But I think any new international court is bound to learn from the mistakes that were made by the International Criminal Court. You know, let me say this in answer to all the questions. The politics of international criminal justice cannot be ignored. That politics applies to every single international institution, from the United Nations to regional institutions, to the AU, to the American, to the Caribbean, to the European. The politics cannot be divorced. That's a given, and one must work as best as one can within those political constraints. It's the answer to the second question, really. How do you get the strong states to come in? The strong states don't like being involved, and that's true. Most of the powerful nations don't like international institutions. The Russians, the Chinese, the Indian government don't like international institutions to be looking at them. The United States is probably the most ambiguous. Certainly it was before the present administration. Their attitude was, international institutions, excellent idea, but for you, the rest of the world, leave us out of it. We're in an exceptional position. We're not prepared to have international judges and international prosecutors looking into our nationals. It's a good idea, you do it, but leave us out of it. So there was that duality in the case of the United States, which still continues today. That's again the politics. The United Nations is bedeviled by the politics created by the veto power of the Permanent Five. It considerably weakens the United Nations Security Council. But I suggest it's no reason to do away with the United Nations. We have to deal with it in the best way we can. And the less powerful states have to work together to overcome that difficulty to the best of their ability. So I don't think these are issues which don't lead to the conclusion that we don't need or that we shouldn't have international institutions. We must make these institutions work as well as possible. It's the reason, too, to get the AU involved at this stage, and we would certainly welcome any involvement. The African Union really has been very supportive of continental, of regional, of African solutions to grand corruption. It's there well documented and well represented in the Malombo Protocol, but it doesn't get very much further. It's very concerning that there's only one state so far, one African state, one member of the African Union that has ratified that protocol. So it's strong in the theory, but rather weak in the implementation. Finally, and I know that you're running late, but finally the question: why not use the International Criminal Court? Well, that would be a great solution, but it's really not a practical one, for a number of reasons. Firstly, the Rome Statute makes no provision for corruption as a crime. It would only be possibly if it reached the stage of crimes against humanity, which is very difficult to imagine that corruption could be charged in the International Criminal Court. Then people say, why don't you amend the Rome Statute to include corruption? Well, to amend the Rome Statute requires no less than a 7/8 agreement in the Assembly of States Parties, and even if they agree, states parties that weren't there originally can opt out of the effect of any amendments. So it's not going to, it will probably take 10 or 20 years to get such an amendment considered. And the prospect of getting that sort of majority in favour is almost out of the question. There are just too many dishonest states in the Assembly of States parties of the ICC that would certainly defeat any such a move. Thirdly, even if it was amended, the court would really have to reorganise. At the moment, there are no judges, no investigators, no prosecutors. There's nobody in the International Criminal Court who has experience and expertise in fraud and money laundering and corruption generally. So it would have to start from the beginning. And fourthly, I wouldn't like to be a prosecutor having to choose between genocide and crimes against humanity on the one hand and grand corruption on the other. I think grand corruption in too many cases in a court that's starved of money, starved of personnel, would fall off the table. Corruption is too important and too large and too common in virtually every country of the world to leave it in that haphazard way. We need a special, dedicated court dealing with internationalized money laundering. Thank you very much.
Thank you very much, Justice Goldstone, for the explanation, and also thank you for the speakers, because your questions were based on pertinent issues. The fact is that we all want corruption to be fought. There's no question about that. And the fact is that there is grand corruption in every country, and we want every country to be subjected to the same justice. Justice, where bigger economy are subjected to, should be the same justice smaller economy should be subjected to. That is the feeling that I got from the members of this conference, Justice Goldstone. And whatever you are going to put in place, make sure that this will apply to all countries. Those who will be sponsoring the establishment and those who are poor, not able to sponsor the establishment. Because Africa had had enough. Up to now, Africa, as you know, justice is not represented on the UN Security Council as a veto power. Thank you very much. Let us give the Justice Goldstone another round of applause, please. Thank you very much.
So thank you for the presentation, and also he deserved a round of applause for the chair. I was a little scared. I thought he was going to give another presentation on that. But it's a very topical issue anyway, so let's hope that it works. But sometimes they also have to go a little slowly on this. You know, much as corruption is bad,